It's almost time for us to get started, so if folks want to make their way inside and find a seat, I've got a couple housekeeping items for the conference before we get going.
Wait till the end of the question before you...
First of all, you can go to the Conference Resource Center for any of the handouts that you need and also the bios. As you've been reminded of a couple times, the sessions are recorded, so if you have a question and you're asking a question, just wait for me to run the mic over to you and I'll make sure everyone is able to hear you. Please don't forget to fill out the evaluations. This is my second year as on the PEC leadership, and we go over those evaluations very carefully to try and improve the conference each time we meet. So those will be taken seriously by a number of people. And finally, tomorrow on Tuesday, there's 2 informal meetups in the morning at 8:15. There's a new member meetup where you can meet some EBA leadership, folks from EBA leadership. And then there's an in-house only session in room 2, up one floor up, for in-house counsel only. So you won't be pestered by people looking for business like me. So with that, I'll hand things off to Sam Brumberg, and he'll explain the rules of Jeopardy.
All right. Thanks very much. Appreciate it. Well, good afternoon, everyone, and welcome to Legal Ethics Jeopardy. Because James Holzhauer has ruined regular Jeopardy for everyone, we've come up with our own legal ethics version. This one is much, much better, I'm sure you'll agree, than original Jeopardy. Before I begin, I want to pay a special tribute to those law firm associates that helped us with the printed materials. Those are all being made available to you online, and there are some packets at your seats. I want to thank Pat Alexander, Susan Bergels, Allison Conley, Florence Davis, Larry Eisenstadt, Caitlin Farrell, Diana Jensky, Cecil Martin, Tyler O'Connor, Lamia Rahman, and Holly Rachel Smith of Crowell & Mooring, Exelon, Day Pitney, McGuire Woods, Blank Rome. Thanks to all of you. We could not do it without you, and you are deserving of our special tribute. I'd like to go ahead and introduce our judges. I'm going to ask each of you to introduce yourselves with your name and your organization, your affiliation, and then perhaps give us a fun fact about yourself. I'll go first, so you can see how it works. My name is Sam Brumberg. I'm counsel to the Virginia, Maryland, and Delaware Association of Electric Cooperatives, headquartered in Richmond. So happy to be here today. I'm here because I was one of the originators of the Legal Ethics Jeopardy format, which was, I believe, debuted in the mid-2000s at the the improperly named Virginia National Regulatory Conference, held every year. Fun fact, I do a very, very passable Donald Trump impression, which you all will not be hearing today.
I'm Saul Singer. I am Senior Legal Ethics Counsel at the D.C. Bar, in which capacity I write articles on ethics, answer thousands of inquiries a year, et cetera, et cetera. Fun fact, I still maintain my delusions regarding my competency on the basketball court. And I've recently found out that there's a real good reason why there aren't a lot of 67-year-olds out there banging around anymore.
Good afternoon. I'm Judge Cintron. I am not an ethics expert, and recently I will demonstrate that I really am not. Recently, I had some of my judges pay for a conference, and then the ethics expert in the agency said we did not have to pay. Too late, we had already paid. Fun fact, I have a number of hobbies, and some of you know what they are, so I'm not going to share them.
I'm Seth Guggenheim. I do for the Virginia State Bar what Saul does for the D.C. Bar. I'm an assistant ethics counsel. I man the hotline, rotating with my other 3 department attorneys, and I help write articles, CLE materials. I give presentations and so forth. I help the Legal Ethics Committee generate its opinions. Before that, I was a prosecutor for the Virginia State Bar for 12 years, 2000 through 2012, and I've been with the ethics department since 2012. The fun fact is that I told Sam when I arrived that before I was asked to do this and became familiar with the organization, I thought an energy bar was something that you ate.
Thank you all, and we are grateful to all of you for serving. Now it's time to meet the contestants. The ladies team, Adrienne Claire, Emma Hand, and Susan Olenchuk, ain't no party like an ex-party. Ladies, please introduce yourselves.
That's pretty good.
Good afternoon. My name is Susan Olenchuk, and I am a partner with the law firm of Van Ness Feldman. And my fun fact is that I am a diehard Michigan Wolverine, married to a diehard Ohio State Buckeye. And our immediate goal in life is to go to football games at every single Big Ten stadium, and we're about halfway there.
Good afternoon. My name is Adrienne Claire. I'm a partner. I'm going to say my law firm if we win, so I'll wait and hold that. I am proudly admitted to jurisdictions which do not have a continuing legal education requirement, which was fun until this moment.
Hi, I'm Emma Hand. I'm a partner at Denton's. My fun fact is that my husband has actually been on Jeopardy, so I've gone out and watched a studio taping, and that was fun. So.
Thank you very much, ladies. And for the gentlemen, Matt Rodolfi, John Schneider, and Bob Weishar, the Alex Trebethicists.
Hi, I'm Matt Rudolph. I am a partner at the law firm of Duncan, Weinberg, Ginzer, and Pembroke. And a fun fact is I bought a surfboard last year and have never surfed.
I'm Bob Weissar with McNeese, Wallace, and Nurek. Fun fact, I was in the National Spelling Bee. I won't tell you what year, but it was long before they started broadcasting it on ESPN.
Hi, I'm Jonathan Schneider. I really don't have a fun fact so much as I do have a bit of research to share. I looked at the bylaws of the association before showing up and realized that there's no procedure for impeachment. And even if there were, acts before you become the president are not relevant to impeachment.
Thank you all very much. Finally, as we start our game here, I'd just like to note we have a prize for the winners. The winning team will receive a Virginia wine tour in a vintage 1973 Volkswagen van. This is for real. This is not a joke. This is a real wine tour that you can go on. The winning team will be able to go, and remember, the team that wins together drinks together.
I like that.
All right, is everybody ready?
This is Jeopardy! First round, the Jeopardy round.
All right, by virtue of a coin toss, the ladies will go first. Ain't no parte? I'm sorry, I should also announce the categories. The categories are no potent potables here, ladies and gentlemen, conflicts of interest, ethics at FERC, new and improved, oops, I didn't mean to upload that, and practice before FERC.
We'll take practice before FERC for 10 points, please.
Practice before FERC for 10 points. That is starts on page 13 of your printed materials, question 21. This acronym is used to describe engineering, vulnerability, or detailed design information about proposed or existing infrastructure that relates to production, generation, transmission, or distribution of energy, could be useful to a person planning an attack, is exempt from mandatory disclosure under FOIA, and gives strategic information other than the location of the infrastructure. Ain't no party.
What is CEII?
That is correct. 10 points.
Very good.
10 points for Ain't No Party. Ain't No Party, it's your board.
We'll take practice before FERC for 20 points.
Practice before FERC for 20 points, page 14 of your printed materials. Question 22. A complainant may file a complaint under FERC Rule of Practice and Procedure under FERC's Rule of Practice and Procedure 218's simplified procedures for small controversies if, among other things, the amount in controversy is less than this amount. Alex Trebethis.
What is 20,000?
What is 20,000? I'm sorry, that's incorrect. I'm going to give Ain't No Party a chance, if they want to.
If I get it wrong, do we lose points?
Yes.
Okay, no.
All right. The answer is, what is $100,000? So that's negative 20 points for the gentleman.
You all need to go to Judge Drink's panel tomorrow.
All right, Ain't No Party, it's your board.
We'll take FERC practice for 30 points.
FERC practice for 30 points, page 14, question 23 of your printed materials. The commission or a presiding officer may exclude any person from a hearing if such person exhibits this type of conduct, which is derived from a Latin word meaning rebellious. Alex Trebethis.
We think it's something like punctilious, or it's close to that.
Could you state your expertly lawyered, hedged full answer in the form of a question?
What is? Oh, what is? Yes, what is that?
I'm sorry, that's not correct. Ladies?
We don't want to lose points.
All right. The ladies, ever cautious and conservative, that's minus 30 points for the gentleman. The answer is contumacious conduct.
Come on!
Weren't you at the hearing when I threatened somebody with doing?
John, I never had to pronounce it.
That's too funny.
All right. Ladies, it's still your board.
We'll take ethics at FERC for 10 points.
Ethics at FERC for 10 points. That is page 6 of your printed materials, question number 6. Under FERC Rule of Practice and Procedure 2201, FERC generally prohibits ex parte communications in this type of proceeding.
What is... I buzzed first.
We buzz first.
I heard the gentleman's buzzer first. So, gentlemen, your answer.
What is a contested proceeding?
Could you be more specific?
What is a contested on-the-record proceeding?
That is correct. A contested on-the-record proceeding. That's 10 points for the gentleman.
I buzzed.
All right. Gentlemen, you're crawling yourselves out of the hole that you made earlier. Good work.
Thanks for
gentlemen,
that,
it's
Sam.
your board.
We'll take conflicts of interest for 10.
Conflicts of interest for 10 points. That's page 1 of your printed materials, question 1. Attorney A wants to represent 2 clients in the same case at FERC. She consults with both clients, and the clients verbally agree to the joint representation. Attorney A then sends this email to other attorneys at her firm, and I quote, "Who's your girl now, folks? I laid it all out there for them, just like Rule 1.7 says, and they both agreed to allow me to represent them. Love me some me, baby." Client 1 ultimately files a bar complaint against Attorney A for representing 2 clients in the same case. Attorney A points to her email as evidence of this? Ladies?
What is written consent?
What is consent? That is correct, ladies, for 10 points.
Yeah, I'll weigh in with a comment here. First, in DC, that would be an incorrect answer. And the reason is, I always stand up, I do a lot of CLE, serve on panels and whatnot, and I always say that there isn't a single thing that a lawyer can do under the DC rules with the client's consent that the lawyer would not be able to do otherwise. And people look at me like I'm insane. And the reason is because it has to be informed consent. Very big difference. And we have a definition, I know the ABA rules do too, which essentially says and makes clear that you're never going to find anything that says, okay, here's the list of information you have to convey in order to render the consent informed, A, B, C, D, and E. Never going to be that way because it's always situational, depends on many factors, the sophistication, vel non of the client, et cetera, et cetera. And at this point, I also think it's very important to mention, and I do this at every single CLE panel I serve on, and that is the importance of Rule 8.5, which is the choice of ethics rule. And this is particularly important for DC lawyers because, as you may or may not know, DC is very much an outlier jurisdiction. We are not a model rule state. We don't follow the ABA rules. We go our own way in many areas, and some we're stricter, and others we're more lenient. So there's very often we'll get a caller on the legal helpline who cites the rule precisely correctly, except it's the wrong rule under the circumstances. So if you haven't looked at Rule 8.5 in a while, you really need to, and the first question, the same way anytime you begin a representation, the first question is always going to be which substantive law applies. In the ethics context, the first question always has to be which ethics rules apply, informed consent, not consent.
Thank you. Seth, did you want to weigh in on that?
I agree with everything that Saul has just said. And when we're teaching them the rules, we have to go by the model rules because we don't really know in advance which rules are going to apply to your individual circumstances. We couldn't know that. And that's how law schools teach ethics, through the model rules. But we're constantly pointing out that there's a difference. No state has completely adopted the model rules as the model rules are written. And California doesn't even have what you call the model rules. They've got their own stuff, which is similar to the model rules, but not the model, not composed largely of the model rules. So it's very important to do what Saul says and find out what state or what jurisdiction's rules apply to your situation. And the choice of law provision, Rule 8.5, that's not even the same in all states, believe it or not. So go figure. One thing about consent that's very important is that it be informed. And this says you should get consent after consultation. But there are times when obtaining consent is not possible, because in order for you to advise parties that you want to give consent, you'd need consent from one party to disclose confidential information to another party. So consent is sometimes not even possible to obtain because it would be a breach of confidentiality. You wouldn't want to reveal something about a client that could be potentially usable by another party to the detriment of that client. So don't let the tail wag the dog here. Don't make the consent happen just because it helps you have two clients. If it's truly a matter where you should have only one client, then just have only one client and be done with it. So informed consent, and the memorialization doesn't have to take a particular format. When it says in writing, it can be memorialized in your file or in other ways, but the best thing to do is to have the clients have a writing showing what the conflict was, how it was explained, and what it is they're consenting to. That's the best thing. And there are some times when you have to put in your memorialization of consent that if a dispute or adversity develops, even though it's unexpected, if based on unforeseeable circumstances it develops, that the lawyer will have to withdraw from both cases, and each client will have to get a different attorney. So be mindful of all those permutations on the subject of consent.
Do you think that, again, given the facts that we know here, do you think that the two-line internal email satisfies the memorialization in writing? Yay or nay?
I wouldn't say. No. It doesn't identify what has been consented to, and it's not something that the lawyer can show to a disciplinary tribunal, which would be persuasive in view of a bar complaint.
Well, all disciplinary tribunals want to hear that she loves her some her, right?
That's true. That is one exception built into our procedures. Absolutely.
This is another area where DC is different, and that is we do not require the informed consent to be in writing. Now, that doesn't mean that it's not a hell of a good idea to do it that way. As a matter of fact, many people don't know. We don't even require the client's signature on a retainer agreement if it's an hourly representation. All that's required is the writing. But again, there's very few times where writings are required, but as a matter of your own practice and protecting both yourselves and the client, getting that signature, putting it in writing is always a very good idea, if not ethically mandated.
Thank you. I do want to offer, we are going to move quickly, but I do want to offer a chance for audience questions if there are any. All right. Ladies, it's still your board.
Okay, Sam, we're going to go practice before FERC for 40 points.
Practice before FERC for 40 points. That is on page 14 of your printed materials. Question number 24, 40 points. All right. Young Gunn hasn't yet memorized the FERC rules of practice and procedure. He knows they are memorialized in 18 CFR, but he can't remember where. To find them, he should turn to this part of 18 CFR. Ladies?
Yeah. What is Part 385?
Part 385, that is correct. That's 40 points for the ladies.
Very good.
It's 40 points for the ladies. And ladies, it's still your board.
Yeah. You have some conditions, but that's not one of them.
But is he getting contumacious?
It's borderline.
We will take practice before FERC for 50 points, thanks.
Practice before FERC for 50 points. This is on page 14, question 25 in your printed materials. All right. Young Gun works for a large electric utility. On his first day of work, he has inadvertently caused his new company to violate the Natural Gas Act or the Natural Gas Policy Act. His company may owe up to this amount, which is the maximum civil penalty for each day of the violation. Gentlemen.
$1 million.
What
is $1 million?
I'm going to give you one more chance. Is that your final answer?
We don't do that in Jeopardy.
We'll look it up. Wait a second.
I think they want to phone a friend.
That's wrong game show. All right. Quickly, gentlemen. Time is running out. All right. I'm sorry, gentlemen. That's not correct. $1 million is not the correct answer. I'm going to give the ladies a chance. No?
Chickens.
They're going to sit back and relax. I see. All right. What is $1,269,500 is the correct answer. That's minus 50 points for.
So if we had said $1 million as adjusted for inflation, would that have been correct?
I'd probably hand that one over to the judges to decide. But that's very innovative thinking, though.
If you're doing the inflation calculation back to 1889, maybe.
Look up 166 FERC at 61014. But I agree with you. I used to think it was over $1 million, so that is the correct figure.
All right, ladies, it's your board. Ain't no party.
It's your turn, Adrian.
Close to zero.
We'll take new and improved for 10 points.
New and improved for 10 points. All right, that's page 8 of your printed materials, question 11, page 8. Attorney Alicia Florik's law firm was a target of the infamous Gotta Weep ransomware attack that resulted in a data breach of confidential client information. She is able to satisfy her ethical duty to act reasonably and promptly to stop and mitigate damages of the breach because she had this. I'm going to give you a few more seconds. We've stumped them, ladies and gentlemen. All right, time? You don't have to buzz in. All right. And the answer is an incident response plan. What is an incident response plan? Did you gentlemen want to offer some commentary here?
Yeah, I have a couple of comments here. First of all, I think it's worth talking very briefly about Rule 1.4, which is the duty to communicate with your client. And in D.C., it's so broad, I believe it is in other jurisdictions as well, that whenever anybody calls me and says, do I need to tell my client, I say, yes, now you can finish your question. Because 99% of the time, when a lawyer is hesitating to give information to the client, it ain't because it's in the client's interests. So whatever other issues are flying around here, I think the lawyer has to, as quickly as possible, call the client, tell the client what happened, counsel the client about what's going to happen going forward. Second, in terms of the scope of the duty and exactly what it is that the lawyer has to do pursuant to an incident response plan, that I think is going to be very much on a sliding scale, the same way a lawyer's duty to protect client confidence and secrets is. Under Rule 1.6, duty to maintain and protect client confidences and secrets, ordinarily, you lock up your office at night, you keep the files in a drawer under lock and key, you password protect it on the screen, on the computer. Usually that's enough. But on the other hand, if you're dealing with, for example, national security secrets, having 6 guys there with machine guns may not be enough under the circumstances. So whenever somebody says to me, well, what are the elements of an incident response plan, I kind of compare it to pornography. I know it when I see it. And, there are publications, some of them are available from our bar, regarding some recommended steps. But again, depending on what the situation is, you may have to do a lot more than that.
Thank you, Saul.
Yeah, I agree with everything Saul has just said. And, the bigger firms, I think, have IT professionals that are helping develop these plans and so forth. But as far as what Saul said about Rule 1.4, which has to do with duties of communication, the clients should be apprised of anything that's going to have to put them on extra vigilance for, to guard against the consequences of potential disclosure of confidential information. In some, I think 46 jurisdictions have statutes that require for certain types of personal information that are breached, certain types of notices have to be given as a matter of law. But the incident response plan is going to be, the elements of it will be proportional to the size of the firm, the significance of the confidential information. It's a rule of reason. You're not going to have some guy sitting over a barbershop typing his own stuff have some kind of a $200,000 incident response plan. He just needs to have, or she needs to have, good equipment and use encryption, update things with patches and so forth, get IT advice about guarding against ransomware and so on and so forth. You don't have to pull out all the stops. It has to be proportional to the sensitivity of the information, the size and resources of the firm, and considerations like that.
Thank you. Would refer you in your printed materials to ABA Opinion 483 and just the basic rule of competence. I would also just note you may be under some other legal obligations outside of the ethics rules if you were to suffer a breach like this. That brings us back to the game board. Ladies, it's still yours.
We'll take ethics at FERC for 20 points.
Ethics at FERC for 20 points. That's page 6, question 7 in your printed materials. Page 6, question 7. Under Office of Government Ethics regulations, a FERC employee is prohibited from participating in matters in which the employee knows a reasonable person would question his impartiality without first obtaining approval from this official.
We have nothing to lose, right? Charles, what is Charles Beeman?
You're going to have to rule that a correct answer.
I defer to Your Honor. The designated, I'm sorry, I didn't get
that is.
Ladies, I messed you up there, I'm sorry. The designated agency ethics official, who is?
Mr. Beamo sitting over there.
He's sitting right here. Excellent. All right.
Trying to be inconspicuous.
That's 20 points for the gentleman.
Yes.
See, you had nothing to lose and it paid off for you. All right, gentlemen, it's your board.
What do we want? We'll take ethics at FERC for 30.
Ethics at FERC for 30 points, page 6, question 8 in your printed materials. Young Gun recently joined FERC staff. His wife owns shares of a large public utility. Under FERC's rules, Young Gun must report his wife's equity interest to the designated agency ethics official within this number of days of joining the agency.
We have almost nothing to lose. We have almost nothing, close to nothing to lose, right?
It's not a million.
What is 30? 1,269,000. Thank you for that tip.
And extra help was free.
What is 30 days?
What is 30 days? That is correct. That's 30 points for the gentleman, and they maintain control of the board. Gentlemen, it's your board.
We'll take, oops, I didn't mean to upload that for 10.
Oops, I didn't mean to upload that for 10, page 12, question 16 in your printed materials. Page 12, question 16. By clicking on a link in an email that appeared to come from her IT department asking her to change her password, Attorney Elle Woods inadvertently opened up her entire email server to a hacker. Elle had recently received some incredibly sensitive client information, but she was able to reassure her clients that all of their information remained secure because it was protected by this. Ain't no party.
What is encryption?
That is correct. That's 10 points for the ladies.
Again, the firm, the lawyer, would have to contact each of its clients, even before it necessarily knew how many of them were affected. This is straight 1.4 again.
I don't know that I agree specifically with that. It really depends on the nature of the client's matter and what the consequence of a breach might be.
I'm going to pause, see if there's any audience questions on that one. All right. Gentlemen, it's your board.
Hey, we got that
I'm sorry.
right.
No. I apologize. Ladies, it's your board.
We have another session at 3:30.
We'll take. Oh, don't get short-tempered, loser. Just hang on. We'll take ethics at FERC for 40 points, please.
Ethics at FERC for 40 points. That is page 6, question 9 of your printed materials. Question 9, 40 points. Young Gun is still employed at FERC but looking to leverage his FERC experience in the private sector. He's entered into negotiations for employment with Rate Base R Us, LLC. During the course of those negotiations, Young Gun is prohibited from doing this.
What is working on any cases involving rate base are us?
Could you be more specific?
He has to formally recuse himself from any cases that they would be involved in, and probably a broader recusal of that entire category of cases if he's negotiating in that sector.
All right. I'm going to let the judge speak on this briefly and then let her decide if that is sufficiently correct.
I think the answer is substantially correct. In our office, every 2 years when our law clerks are looking for work on the outside, we do not let them get involved in any cases that deal at all with any of the law firms that they are seeking employment with. So in cases of doubt, don't do it. If you have participated in a matter, you can't be in it.
And this is an important area where FERC and the state rules diverge. This question is really meant to address the recusal issue that Emma properly raised, and it turns on how affected Rate Base R Us is in any particular matter. Points for Ain't No Party, and they maintain control.
We'll take conflicts of interest for 20 points.
Conflicts of interest for 20 points, page 2, question 2 of your printed materials. Page 2, question 2 for 20 points. A lawyer who has formerly represented a client in a matter, or whose the trebethicists.
What is disclosure and use information for personal gain?
I think that is sufficiently correct. I'm going to let our judges give the final word on that.
Well, I think the reason we're hesitating is because our respective rules may very be different than the ABA model answer given here.
Advantage of the former client, you mentioned that, and reveal information relating to the representation, you mentioned that as well. I think this is ripe for some commentary from our judges.
So let me talk how DC approaches this. First of all, our Rule 1.9 does not contain anything regarding confidences and secrets. It is a separate duty. So essentially, there are two duties that a DC lawyer owes a former client. The first is really much broader than past the life of the client. And we give entire COEs on this, but standing on one foot right now, let's just say that duty extends not only to attorney-client communications, which everybody kind of knows about, but to any information whatsoever that a lawyer learns through or in the course of the representation, whether directly from the client or even from some third source or other person. And under our rules, unlike under the model rules or the ABA rules, the Rule 1.6 duty sort of is the mother of all rules. It generally trumps other ethical imperatives. It is kind of central to everything. And in terms of Rule 1.9, which I won't go into now, there's this thing called the substantial relationship test. But I always say 1.6 is probably the central rule under the DC rules. As I say, it's extremely broad. And the example I give in that in some context, if that causes embarrassment or detriment to the client, or the client doesn't want the lawyer to do it, that's a client secret which 30 million people know about. So, for us, we have to be really careful about this. Under this hypothetical here, it doesn't have anything to do with whether it's related to the representation or not. The lawyer can't repeat it. If I happen to know that my client has Redskins, it's not relevant, but it's a secret that I'm bound to keep nonetheless.
I agree with everything Saul has said, and there are CLEs and CLE segments of some significance on the subject of what is meant by generally known in this rule. And there are exceptions. You can't. There's a different. This rule 1.9c talks about two things. Somebody came to you, say, for a collection case, and the claim was against a former client of yours. That wouldn't require that you discuss anything necessarily with the client and reveal a confidence about the former client, but you would be using information to the detriment of the former client if you knew that the former client had a possession of an extremely valuable piece of jewelry, that item, for the client who's has a debt, who's a creditor of your former client. That would be using information to the detriment of the former client because you gained knowledge of this valuable piece of information from the former client. But what if the former client was an actress who was well known, went on all the late night talk shows and so forth, and in fashion magazines was displaying and talking about that item on behalf of a subsequent client, because what you're representing the subsequent client on was not the same or substantially related to the former client's matter, which had to do with a divorce. So there's lots of nuances here, but you should err on the side of caution. And Rule 1.9c, especially C2, essentially extends the application of Rule 1.6 to former clients. If Rule 1.9c extends the obligation to keep confidences to former clients. And as Saul said, that confidentiality survives death, and it's something that you have to hold inviolate, especially if it would be detrimental to the interests even of a deceased client. Now, let me say that Rule 1.9c1 says, use information relating to or gained in the course of the representation. That says you met the former client in a pizzeria 2 days before. That would not be covered by Rule 1.9 because it was not in any way related to or occurring during the course of the professional relationship or the attorney-client relationship. So, this is highly nuanced, and you have to just assess what you're dealing with based on thinking about this.
Just give you an example in that context of the substantial relationship test. Let's say I represent a landlord in a landlord-tenant case, and that case is over. It doesn't matter if it ended 5 minutes ago or 50 years ago. That landlord is a former client, and now a client in a personal injury case retains me to sue that very landlord. The landlord comes over to me in court and he says, what are you doing here? You were my lawyer. And the answer is, well, yes. If during the course of representing that landlord, I learned that he's a little bit of a blowhard, and he prides himself on not insuring himself, not purchasing proper insurance. And his attitude is, I'm wealthy, I got the money, I'll self-insure it. If I'm held liable, I'll pay it. And one of the issues now in this personal injury case is whether that guy has insurance. That's clearly information that's not only a client's secret, but has become relevant to the point that the matters are now substantially related so as to preclude the...
Conflicts of interest for 30. That's page 2, question 3 of your printed materials. This term means that lawyers in the same firm shall not knowingly represent a client when any one of the firm's lawyers practicing alone would be prohibited from doing so. Ain't no party.
What is imputed disqualification?
That is correct.
Very good.
30 points for the ladies.
There are a number of exceptions to that firm. There's certain screening mechanisms that are allowed. Again, a lot of subtleties, a lot of exceptions, a lot of rules here, which you should be familiar with rather than just, the answer is clearly correct to the question as posed, but as I say, there are subtleties that you need to be careful about.
All right. We're going to take just a brief moment and check in with our official scorekeeper just to see how the teams are doing.
That's right.
It's a bloodbath.
It's a...
Whoa.
That's a negative.
Thank you. Thank you very much. Thank you very much. Still anyone's game. we've still got our big ticket questions left here, so it's not too late. Ladies, it's your turn.
Alex, do we have any daily doubles here?
There are no daily doubles. There are a small handful of bonus points. I know we've already passed. That's page 8, question 12. Page 8, question 12, new and improved for 20. Defense attorney Perry Mason would like to represent John Doe, but unfortunately, John does not have the funds to cover Perry's legal fees. John expresses an interest in using a broker to finance his legal fees and asks Perry for a referral. Alpha Advisors has provided the most favorable quote, but Perry refers John to his. Ain't no party.
We'll go with the rule against personal conflicts of interest.
The rule, that is correct. The rule against conflict of interest. Very brief commentary if you feel any is necessary.
We can skip it now.
All right. Board.
We'll go with, oops, I didn't mean to upload that for 20 points.
Oops, I didn't mean to upload that for 20 points. That's page 12, question 17. Page 12, question 17 for 20 points. Attorney Vinnie Gambini is representing his cousin Bill, who works for a state electric energy cooperative and was indicted after an FBI investigation revealed that co-op officials used federal grant money to go on extravagant yearly trips to Coachella. Vinnie filed a response to the FBI allegations against Bill, who is supposed to be a cooperating witness with the federal court under seal. He then submitted a version for public filing, removing sensitive information about Bill's naked mud dancing at Coachella using the handy word track changes feature. Unfortunately, reporters are easily able to crack the code by reading the struck-through language, and soon Bill's exploits are splashed across the headlines of that Ain't No Party.
What is redaction?
That is correct.
Ethical issue implied here is Rule 1.1, thou shalt be competent. And we do not have the equivalent to your comment 8, which talks about a lawyer having to be up to date on relevant technology, etc. I serve as counsel to the Rules Committee or hire somebody who can handle that for you on the case.
In terms of fair practice, calling the whole document confidential or privileged is not good.
Yeah. And I would add to what Saul said by saying that many jurisdictions now have 1.6, the equivalent of 1.6C under the model rules. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to something that's easily knowable. And you use them anyway, you could be subject to discipline for having violated client confidentiality.
Thank you. We've got about 20 minutes left. I think we have a fair shot at meeting these questions, but if we do run up against our 2:15 deadline, we'll stop with about 5 minutes remaining and have final Jeopardy. Ladies, it's your board. That was 20 points for the ladies, and it's still your call.
We'll take new and improved for 30.
Bob attended an energy law CLE, after which he received a certificate of attendance, after which he adds certified specialist in energy law to his website. He also publishes a blog post analyzing his client's litigation strategy for an upcoming trial. Bob has violated these rules of professional conduct. Alex Trebethicists.
What are the rules regarding advertising?
So I'm going to help you out here because we heard earlier from Tom that it was a bloodbath. It's a three-part answer, and you've got one, the advertising piece.
Number 2 is the what is the rule regarding confidentiality?
All right. All right. I'm going to give the. No? You think you've got something?
The third one is about puffery or holding yourself out as a specialist. Prohibitions.
Based on the model rules, we have an issue about disclosure of client information. We have an issue about trial publicity, the advertising that was done. And then we have an issue about communications concerning a lawyer's services, the certified specialist language.
Yeah, so time's a ticking, so I'll be quick. First of all, as to Rule 3.6, publicity, our comment 1 makes this a really hard, fact-specific inquiry, because so it's a question of balancing the lawyer and the lawyer's free speech rights against the right to a fair trial, etc. Second, as far as advertising is concerned, we are sort of a hybrid. We do not follow the ABA rules. We don't have any of this stuff about how you can't call yourself a specialist, about how the envelope has to have the name of some lawyer. You know, we don't have any of that. We think advertising is wonderful, win-win. The lawyer wins, time doesn't permit it. Number 2, what you say has to be empirically verifiable. And number 3, this is where the rubber hits the road. It's a really high standard. It can't be potentially misleading to a reasonable person. Very high standard. So if you're going to say, tried 30 civil rights cases and won them all, you would have to have language, because that's potentially misleading. You'd have to have language that says, of course, every case stands on its own, that you're operating under.
Yeah, I agree with everything Saul has said, but the words certified specialist in energy law advertised, which really meant that he had a pulse and a body temperature at the time he went to this CLE. That is false, and that is misleading, and that is something for which discipline could be administered. As far as trial publicity goes, if you say something about the potential for unfairness in an adjudicative proceeding and so forth, we don't have enough facts here to know about that. And not every jurisdiction has the same 3.6. In Virginia, for example, the trial publicity provision in 3.6 relates only to criminal cases tried by a jury. The model rules refer to all cases, even
at FERC for 50. Ethics at FERC for 50, bottom of page 6, question 10. Bottom of page 6, question 10 for 50 points, and that was 30 for the gentleman. After protracted negotiations, Young Gun leaves FERC to join Rate Base or Us, which was involved in several matters pending before the Commission. Because Young Gun was responsible for one of those, and again, we're looking for a FERC answer here.
Well,
Trebethesis?
we're really sure he can't do it. And because they didn't ring the buzzer, we're going to take a shot at violation of duty of...
Something like the rule against subsequent employment. It's like for a year you can't touch anything you touched, but we can't remember what it's called.
Ladies,
Judge Cintron was nodding.
You should not doubt yourself, because you are correct. The 1 year rule, what is the prohibition on former FERC employees participating within 1 year of leaving FERC in any proceeding or matter for which they had official responsibility?
And that's right, official responsibility being 1 year.
Alex, I'm afraid I have to raise this issue. Is there no requirement under our...
It's your board. Let's keep going quickly now.
Not just a 1 year rule.
We'll take conflicts of interest for 40 points.
Conflicts of interest for 40. This is page 3, question 4. Page 3, question 4, conflicts for 40. Mary, a former FERC enforcement attorney, becomes a partner at a law firm. An energy trader calls the firm seeking representation after the company received a call from FERC enforcement about potential...
Assuming that we are outside the 1 year time frame, it would be whether she had actually worked on the case involving that energy trader and what FERC was doing on that before she left the FERC.
I'm going to pause and let the judge come in here and judge if you feel that that's a footnote about the differences between the FERC rules and the state
Okay,
rules.
well, I think it's important, valuable to at least point out the intersection of substantive law and ethics law in this instance. So it's a black letter rule of legal ethics that a statute, a rule, a court order will trump the rules of professional conduct. But that applies generally only when the substantive law is mandatory.
Conflicts of interest for 50.
Conflicts of interest for 50 points. That's page 5, question 5, conflicts of interest for 50. Attorney A represents two clients in the same case before FERC. During the engagement, he learns juicy, confidential information about each client. One client wants to, the gentleman.
Yeah, I think there are some facts that are really missing here. And the salient one, first of all, is whether this is a joint representation where the lawyer is representing both of them as a unit, or a representation where he happens to be representing two separate clients. In the former case, where he's representing both of them, it's them. To produce this to me, the metaphor is getting the animals back after the barn door is open, unringing the bell. Not only may you use it, but you would ethically have a duty to your client to use it to maximize the benefit to the client. Again, our 4.4b is very different than, I think, I've never done a survey of all the other states. We may or may not be the only one to do this, but it's quite different. Which is why you got the biz, by the way, gentlemen.
Virginia doesn't have a Rule 4.4b, but we're working on one. And there's one before the Virginia State Bar Council's June meeting. But basically, we have something known as Legal Ethics Opinion 1702, which, outside of a litigation context, if you receive something and you know, and you start reading it, and you come to know of the fact that it was inadvertently sent, and it's privileged, you have to notify the sender and follow instructions, which can mean delete it or destroy it or return it, depending on whether it's electronic or otherwise. But, we like to think that the golden rule should apply here. You're going to make an inadvertent transmission sometime in your legal career, and you would want your adversary to notify you and to stop reading. This is the golden rule. And the idea that you glom onto something that you're not supposed to have and make maximum use of it both contributes to a breach of the attorney-client relationship. The duty of confidentiality between opposing counsel and the client. It's an intrusion into that. And also it smacks of unfairness and fair dealing. So we have stop reading and notify the sender and follow the sender's instruction. In a litigation context, you might be able to sequester the document under the discovery rules and then adjudicate whether or not it's admissible or can be used. Now, there are going to be some inadvertently sent things that you really don't know whether they were inadvertently sent. It's peculiar that you got it, but it doesn't say, "Dear client, I've got a great idea for a strategy in this case." That would tell you, you could read that one sentence and know you should stop reading. There's nothing obscure about that or abstruse. So it really depends on the context. But in Virginia, stop reading, notify the sender, follow his or her instructions.
So
Ladies and gentlemen, 8.5.
An important difference between the jurisdictions here. Gentlemen, it's your board. 4 questions remain.
Oops, I didn't mean to upload that for 40.
Oops, I didn't mean to upload that for 40. That is page 13, question 19 in your printed materials. Page 13, question 19. Attorney Allie McBeal likes to show how accessible she is by encouraging clients to text her on her 10-year-old completely unsecured flip phone. One of her contacts at client Cyberdyne recently texted her about the company's top secret upcoming merger with InGen Technologies. Allie texts all of her closest relatives and Martha Stewart, urging them to buy more InGen stock. Later that day, Allie's phone is stolen, and the following day, trading in InGen is extremely heavy. In addition to engaging in insider trading, Allie has violated this rule of professional conduct. Gentlemen.
What is maintaining client confidence?
Maintaining client confidence. We would have also accepted keeping abreast of changes in the law and keeping abreast of relevant technology. That is correct for 40 points for the gentleman. All right, gentlemen, it's still your board. We've got 3 questions left. Which one will you have?
I will take new and improved for 40.
New and improved. New and improved for 40, that's page 10, question 14. Page 10, question 14. Lewis finds out that Mike practices technology, a religion whose core belief is that Martians control humans through cybernetic brain implants. Put off by Mike's religious views, Lewis avoids assigning him any cases and passes on him for promotions, instead promoting less qualified associates who are not technologists. Lewis's conduct is an example of this. Gentlemen.
What is discrimination based on religion?
That is correct. That's 40 points for the gentleman, and they maintain control.
I would just mention that DC's Rule 9.1 applies only as to discrimination in employment, but of course all relevant local and federal statutes regarding discrimination are going to apply anyway.
Thank you. Gentlemen, what's your pick?
Oops for 50.
Oops for 50. That is page 13, question 19. Page 13, question 20. I apologize. Page 13, question 20. Attorney Miranda Hobbs is defending a client accused of sending illicit photos to a coworker. Her client claims that sending the photos was an accident, and the photos were really just close-ups of fungi in his backyard. Looking for a second opinion before bringing in a fungus expert, Miranda attaches one of the photos to a WhatsApp chat she's in with some other lawyer friends of hers to get their opinions. Miranda's behavior in this instance has violated this rule of professional conduct. Ladies.
What is the rule of confidentiality?
Rule of confidentiality, that is one. We would have also accepted, again, keep abreast of changes in the law and technology, or revealing confidential information, or preventing reasonable efforts to prevent inadvertent access to confidential information. That is 50 points for the ladies.
The DC rule has an exception to Rule 1.6 that permits lawyers to seek consultations with other lawyers or other professionals in a limited way to get advice. Clearly, going online and doing it this way is not the way to do it.
All right. We've got one question left. That is new and improved for 50 points. Ladies, it's your question. That's page 11, question 15 in your printed materials. Page 11, question 15. Mike Ross observes that his firm employs and promotes very few lawyers who are women, people of color, or members of the LGBTQ community. In response, he implements a series of recruiting, mentoring, and career development initiatives that are targeted specifically to female, minority, and LGBTQ attorneys. Mike's conduct is permissible under the model rules because it is an example of this. Ain't no party.
What is anti-discrimination or affirmative action?
I believe that's correct. We were looking for diversity and inclusion, but your answer is correct. That's 50 points for the ladies. And we're now going to proceed to Final Jeopardy. Yeah, we are. Okay, so Tom's going to give us the scores. That's how much money you have to wager. You're going to write your wager on that piece of paper there in front of you and pass it to Tom, and then I'm going to show you the question. So, Tom, how did the team stand?
Everyone hear me? Is this on?
Yes.
Is it on now? Okay. The women have 390 points, and the men have 120 points.
All right. You can wager up to your full amount if you wish. The category is FERC practice. All right. So please write your wager. The category is FERC practice. All right. Tom's, make your wager. Make your wager, please, and pass that to Tom. Tom's going to collect your wager slips. All right. The question is, and you're going to write the answer and pass those answers up. Just like in real Jeopardy, you're going to write the answer. The question is, this official is responsible for assigning a presiding judge and setting a hearing schedule for administrative litigation at FERC. All right, we've got our answers here. Okay, thank you. All right, from the gentleman, it appears your first answer is, we'd like to buy a vowel. And the answer is, what is the chief administrative law judge? That is correct. And you wagered 0. Gentlemen. The ladies, ain't no party. Your answer is, who is the chief administrative law judge? Judge Cintron. That is also correct. And you wagered 75.1. Please join me in thanking, the ladies have prevailed. The ladies have prevailed, and they will be enjoying their wine tour in due time later this summer. Thank you all, contestants and judges alike. Thank you very much. And to all of you, thank you. Don't forget to help control the pet population. Have your pet spayed or neutered.